A very warm good afternoon to all of you. This is Pratyush Kumar from National Law University, Delhi, speaking on module Legal Principles of International Intellectual Property Regime, Introduction to Trade-Related Aspects of Intellectual Property Rights. The legal principles forming the foundation for intellectual property law governing the world today has been fairly old. It began with the Paris Convention for the Protection of Industrial Property 1883, which is commonly known as Paris Convention, followed with the Berne Convention for the Protection of Literary and Artistic Works 1886, Berne Convention. Both these conventions were also negotiated, renegotiated and amended over the years before they were finally embedded in TRIPS through the Uruguay round of negotiations 1986 to 1994, which came into effect from 1st January 1995. The three main features of the agreement are standards. It sets the minimum standard of protection to IP provided by each member country. Second, enforcement. It entails domestic legislations, procedures and remedies provided by member countries for the enforcement of IP rights. Third, dispute settlement. Dispute settlement is a unique feature of the World Trade Organization, which provides for a complex system of dispute settlement through dispute settlement understanding. Principles which got enshrined in the Berne Convention 1886, which forms the bedrock of IP law today, are: first, principle of national treatment. Principle of national treatment. According to this principle, a treatment no less favorable is provided to nationals of other member countries as nationals of one's own country. This principle is enshrined very much in the General Agreement on Tariffs and Trade and forms as one of the bedrock principles of World Trade Organization structure. The principle and its exceptions have been included in Paris Convention 1967, the Berne Convention 1971 and Rome Convention 1961. Rome Convention for the Protection of Performers, Producers of Phonograms and Broadcasting Organizations. First case is Havana Club trademark dispute case. Brief facts of the case. In this case, the European Union challenged a United States law alleging that it prohibited the registration and enforcement in the United States of a Cuban trademark, Havana Club rum, which was licensed to a French company. They further alleged that it was in violation of the World Trade Organization agreement. The text of section 211 subsection A subsection 2 of the impugned statute states, no US court shall recognize, enforce or otherwise validate any assertion of rights by a designated national based on common law rights or registration of such confiscated mark, trade name or commercial name. World Trade Organization Dispute Settlement Board decision. The WTO DSP held that the US statutory provision section 211A2 violated Article 42 of the TRIPS agreement. Article 42 of the TRIPS agreement requires that members shall make available to right holders civil judicial procedures concerning the enforcement of any intellectual property right covered by this agreement. The panel held that because section 211 restricted foreign nationals' access to US courts to enforce intellectual property rights, it is violative of Article 42 of TRIPS. Claims and decisions. Claim by EU. The European Community claimed that Section 211 is discriminatory because it forces designated nationals, which includes Cubans and any national of any foreign country who is a successor in interest to a designated national, to meet the requirements of Section 211, in addition to successfully completing an Office of Foreign Assets Control hearing. US nationals, in contrast, are not required to meet the requirements of Section 211, but are required to undergo an OFAC hearing, or Office of Foreign Assets Control hearing. Claims by US. US claimed that the Cuban entity in the hypothetical would always be permitted to enforce its trademark rights because original owners are always in a position to consent expressly to their own assertion of rights. The decision rejected this argument because this argument assumed that the original owner of the US trademark is also the original owner of the confiscated Cuban trademark, which is not always the case. Second claim, this hypothetical situation would never occur because the Cuban entity would have registered its trademark before the restrictions included in Section 211A2 were put in place. This was also rejected because it would only be true for statutory registration rights. Section 211A2 applies not only to these rights but also to common law rights. Third claim by US was the Cuban entity in the hypothetical could be considered an unblocked entity under certain provisions of the Cuban embargo, meaning that it would be treated the same as a US entity and that Section 211A2 would not apply. This was again rejected because the board found that in certain instances a Cuban national would not qualify for unblocked status even under the Cuban embargo. In the final decision, the appellate board held that since non-US successors in interest would be forced to surpass an extra hurdle that was not required of US nationals, the provision provided less favorable treatment. Therefore, the appellate body held that Section 211 violated the national treatment provisions of the TRIPS Agreement and the Paris Convention. Next point, principle of automatic protection. Unconditional protection without compliance with any formality in all member countries is provided under TRIPS. Principle of independence of protection. IP rights protection is afforded irrespective of whether protection is afforded in the country of origin or not. Fifth point, principle of minimum standard of protection. This principle concerns works and rights to be protected, duration of protection. Now, for copyright, the different rights protected are translation, adaptations and arrangements of works, performance in public, recitation, communication, broadcast, reproductions, basis for audiovisual works. The sixth point is moral rights of authors. It includes right to claim authorship of the work, right to object to any mutilation, deformation or any modification, right against any derogatory action that would be prejudicial to the author's honor and reputation. Purpose of TRIPS Agreement. The preamble of TRIPS Agreement, along with Article 7, clearly lists out the purposes of the agreement in no less certain terms. First is to reduce distortions and impediments to international trade. Second, to promote effective and adequate protection of intellectual property rights. Third, to ensure that measures and procedures to enforce intellectual property rights do not themselves become barriers to legitimate trade. TRIPS, Article 7, which concerns itself with objectives. It says the protection and enforcement of intellectual property rights should contribute to the promotion of technological innovation and to the transfer and dissemination of technology to the mutual advantage of producers and users of technological knowledge, and in a manner conducive to social and economic welfare and to a balance of rights and obligations. Next point is, all the other WTO agreements essentially affect border measures, whereas TRIPS affects domestic legislations of member countries and has significantly altered the concept of sovereignty. Private parties claim rights protected under TRIPS within domestic jurisdictions that are referred to as persons of other member countries. Article 1.3 defines persons. Next point is Article 1.1 mandates member countries to give effect to the provisions of the agreement. TRIPS Article 1.1 states, members shall give effect to the provisions of this agreement. Members may, but shall not be obliged to, implement in their law more extensive protection than is required by this agreement, provided that such protection does not contravene the provisions of this agreement. Members shall be free to determine the appropriate method of implementing the provisions of this agreement within their own legal system and practice. TRIPS Article 1.3 states, members shall accord the treatment provided for in this agreement to the nationals of other members. In respect of the relevant intellectual property rights, the nationals of other members shall be understood as those natural or legal persons that would meet the criteria for eligibility for protection provided for in the Paris Convention 1967, the Berne Convention 1971, the Rome Convention, and the Treaty on Intellectual Property in respect of integrated circuits were all members of the WTO members of those conventions. Any member availing itself of the possibilities provided in paragraph 3 of Article 5 or paragraph 2 of Article 6 of the Rome Convention shall make a notification as foreseen in those provisions to the Council for Trade related aspects of intellectual property rights, the Council for TRIPS. In the history of IP laws, we observe how the developed countries inter se developed IP rights law over the course of entire 19th century, often violating each other's rights and having differential treatment, and then having evolved their legal system in harmony with each other's IP rights system. This evolved system was then lumped onto the developing world through the TRIPS agreement. In principle, there is no fault with the IP regime developed under TRIPS, but it did not give enough time to the developing world to accommodate and mature to the level of the developed world. No special provisions have been provided to the developing world. Even as far as the least developed countries are concerned, only greater time period for implementation of the same rules have been provided. There is no concession on the rules and principles as such. Principles enshrined in the Paris Convention 1883 included national treatment, right of priority, common rules including patents, inventor having the right to be named, compulsory license, and marks, filing, registration, and renewal of marks, industrial designs, trade names, indications of source, unfair competition. Most favored nation treatment principle was also granted under TRIPS, where it included any advantage, favor, privilege, immunity granted by one member country to nationals of another member country is immediately accorded to nationals of all other member countries. Exceptions are provided under the MFN principle with certain subject matters. international agreements on judicial assistance or law enforcement, rights granted under the Berne Convention 1971 or the Rome Convention based on the treatment accorded in another country, rights of performers, producers of phonograms and broadcasting organizations not provided under this agreement, rights deriving from pre-TRIPS international agreements. Articles 3, 4 and 5 of TRIPS provide for national treatment and most favored nation treatment principle. As intrinsic to the TRIPS regime, it also includes substantive standards of protection, availability of IP rights, acquisition of IP rights, scope of IP rights, maintenance of IP rights, enforcement of IP rights, as well as those affecting the use of such IP rights which are protected under the TRIPS agreement. Article 8 of TRIPS recognizes rights of member countries to adopt measures for public interest, to prevent abuse of IP rights, to improve public health, to adopt measures consistent with TRIPS. TRIPS Articles 7 and 8 together provide the rules for interpretation and implementation of the rights and obligations under the TRIPS agreement. TRIPS Article 7 is one of the few provisions which addresses the concerns of developing countries, as it includes in part, apart from technological innovation, transfer and dissemination of technology, mutual advantage of producers and users of technological knowledge, conducive to social and economic welfare, balance of rights and obligations. The main purpose of IP rights protection through TRIPS has been technological innovation, and as a matter of fact, almost all, if not all, technological innovations still happen in the developed world, and stakes were really high for them to have TRIPS enforced through the Uruguay round of negotiations 1986 to 94. For developing countries, TRIPS Article 7 became the saving grace. It is very pertinent that Articles 7 and 8 have been included in the main treaty of TRIPS and not just in the preamble. Thus, this provision is not just illustrative, it is compulsory. Often developed countries, when enter into any kind of bilateral investment treaty or form a regional trading organization involving developing countries, they ensure TRIPS plus or even stronger IP rights regime as a precondition for forming such an association. Patent protection and an incentive of a minimum of 20 years' control over the protected subject matter have been expected to encourage investment in research and development, though this point is hugely debatable, and there is again a developed world divide, both in terms of approaching the subject as well as in emulating its impact, though it is widely agreed that such long-term and wide protecting provision has actually inhibited innovation. A very strong IPR regime does not ensure flow of technology to the least developed countries. Under TRIPS Article 7, there should also be dissemination of technology, which is percolation of technology through informal mechanisms. TRIPS Article 15 provides the protected subject matter under trademarks. The protected subject matter includes any sign or any combination of signs capable of distinguishing the goods or services of one undertaking from those of other undertakings shall be capable of constituting a trademark. Such signs, in particular words, includes personal names, letters, numerals, figurative elements, and combinations of colors, as well as any combination of such signs, shall be eligible for registration as trademarks. Where signs are not inherently capable of distinguishing the relevant goods or services, members may make registrability depend on distinctiveness acquired through use. Members may require as a condition of registration that signs be visually perceptible. Copyright provides exclusive rights for fixed number of years, whereas trademarks provide limited rights in perpetuity. Industrial designs are also offered protection under TRIPS. TRIPS also evolved the concept of geographical indicators as a recognizable IP law principle deserving protection. Common examples are Indian basmati rice grown in Indian subcontinent, Darjeeling tea grown in Darjeeling, India, or champagne grown in the Champagne district of France. TRIPS Article 2 talks of protection of geographical indications. Geographical indications are, for the purposes of this agreement, indications which identify a good as originating in the territory of a member or a region or locality in that territory, where a given quality, reputation, or other characteristic of the good is essentially attributable to its geographical origin. The second case is US Section 110 subsection 5 Copyright Act case. Now the case concerns Section 101(5) of the US Copyright Act, which allow the amplification of music broadcasts without an authorization and a payment of a fee by food service and drinking establishments and by retail establishments, provided that their size does not exceed a certain square footage limit. On being challenged by the European Union, the panel observed that the section does violate Article 13 of the TRIPS agreement. The reasoning of the report of the panel provides a very important guideline for interpretation of Article 13. The wording of Article 13 does not contain an express limitation in terms of the categories of rights under copyright to which it may apply. It states that limitations or exceptions to exclusive rights can only be made if three conditions are met. First condition: the limitations or exceptions are confined to certain special cases. This requires that a limitation or exception in national legislation should be clearly defined and should be narrow in its scope and reach. On the other hand, a limitation or exception may be compatible with the first condition even if it pursues a special purpose whose underlying legitimacy in a normative sense cannot be discerned. Second point, they do not conflict with a normal exploitation of the work. This requires that the measure does not have a substantial market presence. Which would otherwise be deemed to conflict with normal exploitation. For the purpose of such ascertainment, the both actual and potential effects on the commercial and technological conditions that prevail in the market currently or in the near future have to be analyzed. They do not unreasonably prejudice the legitimate interests of the right holder. Here, interests were held to include those interests that are justifiable in the light of the objectives that underlie the protection of exclusive rights, in addition to actual or potential economic advantage or detriment, prejudice to connote damage, harm, or injury, not unreasonable to connote a slightly stricter threshold than reasonable. It was also said by the panel that a limitation or an exception is consistent with Article 13 only if it fulfills each of the three conditions. The application of Article 13 of the TRIPS agreement to the rights provided under Article 11(1) and 11 bis 1 of the Berne Convention 1971 as incorporated into the TRIPS agreement need not lead to different standards from those applicable under the Berne Convention 1971, given that the possibility of providing minor exceptions forms part of the context of these articles. The next section deals with enforcement and dispute resolution mechanisms. Enforcement. Under Article 9(6) of the Paris Convention, a country was under no obligation to enact legislation permitting seizure or promoting importation of infringing goods. Part 3 of the TRIPS agreement makes it mandatory that members shall ensure that enforcement procedures permit effective action against any act of infringement covered by this agreement, including injunctive relief, Article 44, money damages Article 45, and strong border control measures from Articles 51 to 60. Members are also obliged to frame legislations for criminal prosecution, including seizure, forfeiture and destruction of infringing goods in special cases. Dispute resolution. Article 64 of the TRIPS Agreement provides for setting up of a dispute settlement forum almost on the lines of as dispute settlement under the WTO. Without a means of settling disputes, the laws are bare blank words. The WTO's procedure underscores the rule of law, and it makes the trading system more secure and predictable. The system is based on clear rules and regulations. Disputes are first referred to a panel, which submits its report. From that, appeals on points of law are allowed to the appellate body. Non-violation of TRIPS. Disputes generally arise when a member country shows or alleges the violation of any of the provisions of an agreement by another member country. However, in some situations, a government can go to the dispute settlement body even when no provision of any agreement has been violated. This is called a non-violation complaint. It is allowed if one government can show that it has been deprived of an expected benefit because of another government's action or because of any other situation that exists. Article 64.2 of TRIPS contains a temporary restraint on bringing non-violation complaints. This is called moratorium. It has been extended several times. In October, the TRIPS Council agreed to recommend extending the present period until 31st December 2015. Criticisms of TRIPS. First criticism. TRIPS essentially has nothing to do with trade directly and has ended up prejudicing and restricting trade, which is the mandate of World Trade Organization. Second, IP rights are domestic and territorial and governed by domestic laws and regulations. There is no world patent. Third, one size fits all approach is inappropriate for developing countries. Fourth, companies doing generics are not doing something innovative and have got unwarranted rights protection on it. Fifth, the rationale for TRIPS was trans-border and not domestic, but domestic rights and protection of IP has proliferated over the years. There is nothing trans-border in it. This entire module covers some aspects of the issue that the module concerns itself with. It does not really it hasn't really covered all the different facets and aspects of of the subject, but it is giving a comprehensive view, a rear side view of the subject at hand. Thank you.